Hello friends, today we will discuss an interesting and significant topic in international law, that is use of force. In this video, you will learn how use of force is defined and invoked through Article 2 Clause 4 of the UN Charter. You will see how present clause is different from the previous legal texts. You will also learn the key components concerning use of force and their interpretations adopted by the International Court of Justice. Lastly, we will explore any exception to the use of force. Over and all, this video is going to be really informative and exciting for you. So watch the video till the end. Now before moving further, please like the video and subscribe to this channel for similarly important international law lessons. Let's go. Let me ask you a question. Why do we need any rule concerning prohibition on the use of force in international law? You might say, and as the terminology also suggests, that to prevent states from going into war or fight with each other. Exactly, that's correct. Human history is full of war and violence. Kingdoms fought with each other for numerous reasons. War takes away human lives and affects the economy of a nation. But this practice of war has to end somewhere. States needed a rule to bring peace, stability, and order in the world. Therefore, in the name of progress and scientific development, and also to save humanity and surroundings from the adverse impacts of advancing weapons, for the first time in the human history, we thought of not resorting to war in case of conflict. Well, coming back to our discussion, the concept is clear that states can neither threaten to use force nor actually use force in their international relations. This rule is widely regarded as a peremptory norm. Now, what is peremptory norm? So, it is a norm accepted and recognized by the international community of states as a norm from which no derogation is permitted. But how use of force came into picture? After the First World War, League of Nations was the first attempt made to regulate use of force. However, on reading Article 10 and 12, you will find that these articles do not prohibit use of force strictly, and practically speaking, it was unlikely for any state under attack that it would follow the procedures provided here. Next, in 1928, an attempt was made to prohibit war and compel states to settle their disputes peacefully under Kellogg-Briand Pact. However, as you can see, the language of the text merely renounced the war, but not prohibit it in strict sense. Also, it attempted to renounce only war, meaning thereby any other activity that does not reach up to the level of war was permissible. After the end of World War II, when states realized the potential impact of a war on human life, they again sat together to regulate the use of force and prevent any other war in future. The document they drafted in 1945 was United Nations Charter. Here, you can pause the video and read the article word by word to appreciate the language used in this clause. This provision was significant over the previous two texts for multiple reasons. Firstly, here a strict language is used. The use of word shall signifies that it is mandatory to prohibit the use of force. Secondly, here both employment of actual force and threat to use force are prohibited. Also, the use of word force denotes that the scope of the definition is not only limited to war, but it applies to every instance of use of force. Let us understand this provision in more detail. First of all, when we say that use of force is prohibited, what kind of force are we actually talking? Does it intend to include both armed and unarmed force? Answer is Article 2 Clause 4 is clear that only military or physical force is covered under this provision. Since ultimate purpose of United Nations is to maintain peace and security in the world. Therefore, it does not include forces other than armed ones. For example, imposing economic sanctions by one state on the other is not prohibited here. However, later developments like 1970 Declaration on Principles of International Law requires the states to refrain from any military, political, economic or any other form of coercion aimed against the political independence or territorial integrity. Another important question you may ask about Article 2 Clause 4 is that what constitute threat of force? Threat is similar to the gesture of using force. Therefore, gestures like deploying one's military on the border or issuing verbal warnings coupled with other factors will definitely amount to threat. Further speaking, Article 2 Clause 4 prohibits all forms of illegal threats. But how to distinguish between legal and illegal threats? In the nuclear weapons advisory opinion case, ICJ held that if the actual use of force itself in a given situation is illegal, therefore the threat to use such force will also be illegal and thus prohibited under Article 2 Clause 4. However, if the use of force is legal, then the threats of using such force are also permissible. I will discuss the legality of using force later in this video. Now, the text also says that states shall refrain from using force in their international relations. Does it mean that Article 2 Clause 4 does not apply in domestic context and states can use force against their own subjects? Well, the idea behind UN Charter is clear that states should resolve all their disputes peacefully, whether national or international. Though Article 2 Clause 4 does not mention the word internal relations. However, the spirit of UN Charter read with customary international law prohibits the use of force in internal matters against those seeking equal rights and right to self-determination. Here another line of argument could be that state exercises sovereignty and jurisdiction in internal matters and therefore international law does not apply there. One of the crucial aspects of Article 2 Clause 4 is that threat or use of force shall not be used against the territorial integrity and political independence of any state. Does it mean that those instances of use of force that does not alter territorial limits of another country or does not interfere with the political regime are legal? The answer is no. Many authors have rejected this limited interpretation of Article 2 Clause 4 in the view of the objectives of UN Charter. Therefore, this provision requires broader interpretation and not literal interpretation. States have used forces for multiple reasons like to change governments and establish democracy, security of their citizen in another country, or protection of other citizen. Such acts are often justified on political or moral grounds. At this moment, it is necessary to understand that there are no justifications for using force against another state. Such acts are not permissible under international law. In Corfu Channel case, ICJ specified that the failure to carry out duties by one state does not provide justification to others to injure its sovereignty. So, as of now, we know that use of force is not allowed in the international sphere. However, there are two major exceptions to the prohibition on the use of force. Firstly, states enjoy right to self-defense to defend themselves against an armed attack, either individually or collectively. This right should be based upon the concepts of necessity and proportionality. Talking about its nature, in Nicaragua case, ICJ held that right to self-defense existed as an inherent right both under customary international law and Article 51 of UN Charter. In order to exercise this right, a state must prove that it has suffered an armed attack, though the charter does not define the term armed attack. However, court in Nicaragua case further held that armed attack include acts by regular forces of a state beyond its border or acts by irregular forces acting behalf on that state. However, the court did not recognize that providing logistical or financial support to another state will amount to armed attack. While it is clear that right of self-defense applies to armed attack by other states, the question has been raised whether the right of self-defense applies in response to attacks by non-state entities. Article 51 is silent on whether this right is available against the non-state actors. However, states have interpreted the provision broadly to exercise this right against non-state actors as well. Another instance where use of force is permitted or authorized is under Chapter 7 of the Charter that deals with collective security. Though there is no universally accepted definition of collective security, however, it can be understood as the preponderant use of force approved by the United Nations Security Council to maintain international peace and security. Collective security does not only consist of use of force but involves keeping the peace to prevent aggression. The notion of collective security found its basis under Article 1 of the UN Charter. It states that effective collective measures should be taken for the prevention and removal of the threats to international peace and security. This entire process of collective security remains operative from the moment international peace is threatened or breached till when the Security Council restored the peace. We will quickly look into few provisions that govern collective security under the Charter and understand when exercising force on others is allowed. So you need to understand this process that starts with Article 39. In case of any breach under Article 2 Clause 4 of the Charter, Security Council makes a determination under Article 39 stating the nature of the crisis. Once the Security Council formally determined that a breach of peace or an act of aggression has occurred, it issues provisional measures under Article 40 to reduce the tension between the parties. Provisional measures are immediate, necessary, and temporary that allows parties to think for the present and future course of actions. One example of provisional measure is asking the invading forces to withdraw and directing parties to resolve the dispute through negotiations. After fulfilling these two formalities and observing the failure of provisional measures, Security Council has an option to either issue non-forcible measure under Article 41 or issue forcible measures under Article 42. Article 41 provides imposing economic sanctions against the state causing violations. UN members are prevented to enter or continue any trade activity with the states involved in the conflict and not resorting to peace. If the conflicting states still not comply with the direction provided by the Security Council, it is then Security Council can allow forcible action against violating states under Article 42. Various measures listed in this provision are referred as enforcement action or collective measures. These measures include sending troops in the conflicting areas and attacking other states. These Security Council authorized forces do not stop merely with the end of war, but also take follow-up measures necessary to keep check on the concerned states and ultimately bring peace and security in the region. Now let me conclude our discussion. It was observed that even after the adoption of UN Charter, states were found using force against each other on multiple occasions. Though use of force is a concerning factor, however, the Charter has helped in bringing change in the world affairs. Unlike before, Now states could not expressly acknowledge that they are using force since it is prohibited. Therefore, to justify their use of force, they invoke moral or humanitarian reasons as their primary ground for intervention. States also try to defend their actions with a narrow or broader interpretation of UN Charter as per their suitability. It is essential to understand that the Charter was adopted after the Second World War with one of the essential mandates, that is, to prevent any war or aggression in future. Therefore, use of force is permissible only in self-defense or in accordance with the Charter. Apart from that, all other use of force or threat of force is illegal. This entire realm of use of force is full of many technicalities and different arrangements. Still, I have tried to cover all the basic aspects that will definitely strengthen your fundamental knowledge of this provision. I hope you would have found this video interesting and relevant for your purposes. Show your support by hitting the like and subscribe button. That little use of force is invited. Also, let me know any topic in the comment section on which you want to see the next video. Thank you.